All of the neshamas will have an aliyah, and the families in a chamra. So with that, let us begin. There's no picture by YouTube. I don't know. It's OBS is working in the. Oh no, I'm sorry. It's going. Clicked on. Sorry. All right, let's begin. So today's daf is Kuf Hey 105. We are picking up in Meres Hashem on Kuf Tal Base 104b at the two dots, smack in the middle of the page. So the Mishnah said as follows. Gemara quotes the Mishnah Nasan Los HaKaren. So remember again, the Mishnah said that Halacha L'Maisa. Remember Mishnah talking about the idea that if you steal from someone, swear falsely in order to go ahead and do tshuva, you're obligated in three things: Karen, Chomesh, Asham, and Halacha L'Mais. You also have to go ahead and find the victim and return to him the money wherever he may be. This mitzvah of hashava. So if you remember again, the Mishnah explains that Halacha L'Mais, if you returned the Karen but didn't return the Chomesh, then halacha l'maisa, you are not obligated to pursue the victim. In other words, the obligation of hashava, of running after the victim and returning the object to the victim, is a din in Karen, not a din in Chomesh. So the Gemara says, Amo chum shemamona. So the Gemara says, you see from here that ultimately, again, Chomesh itself is mammon. Chomesh is a monetary obligation, as opposed to, let's say, a knas, or let's say just simply a mitzvah. In other words, or a little bit different than this. In other words, we'll say, what is Chomesh? What is Chomesh? Is Chomesh a piece of financial restitution, or halacha l'maisa is Chomesh just a mitzvah? You now have to pay Chomesh. So the Gemara says, you see from the discussion of the Mishnah that Chomesh is not simply a mitzvah, but rather again Chomesh is mammon. Rashi says, the fact that the Mishnah has to say that you don't have to track down the victim in order to pay Chomesh tells us that what? Without the Mishnah's statement, I would have assumed whatever the din for Karen is the same din for Chomesh. What does that tell you? Ultimately, again, that Chomesh is mammon. Chomesh is actual money, a financial obligation. So the Gemara says, V'im mayis mishamil yarshin. Because therefore what? Therefore halacha l'maisa, if the thief dies, then ultimately his heirs, his children, are obligated to go ahead and make restitution. Utnanami, nasan as a ala chomesh. We'll say similarly again, we learned that if ultimately again the thief pays back the Karen, and then he swore that what? That he paid back the Chomesh, but in fact he didn't pay back the Chomesh. Hari Mosef Chomesh al Chomesh. What do you see? You're obligated to pay a fifth on the fifth. So in other words, remember we saw that case that the Chomesh essentially then becomes the Karen. Alma Chum Shemamonahu. Therefore the Gemara says, you see from here that ultimately again Chomesh is Mammon. So we'll say all of this pointing in the same direction, that Chomesh is part of the financial restitution. It's not simply a nice mitzvah that you have to go ahead and fulfill. The Tanyanami, right? So that supports this. We'll say if Ruvain steals from Shimon and he swore that he did not steal, umes, and now Ruvain died, Yarshin Mishalmin Karen v'Chomesh upturamina asham. Ultimately, Ruvain the thief. So Ruvain's heirs pay back Karen, pay back Chomesh, and are pater from asham. The Gemara says, one second, the Yarshin b'nei shlumi chumsha da'avon havel. Now it's interesting that the inheritors of the thief, right? So the children of Ruvain the thief are obligated to go ahead and pay Chomesh. So the Gemara says, or minu, is that true? Adayin ani omer, a masai inu mishalim Chomesh al gezel aviv. When do we say that halacha l'maisa, the heir, right, the yoresh of a thief, doesn't have to pay Chomesh for the theft of his father? Bizman shelo nishba lo hu v'lo aviv. We'll say that's at a time ultimately again where what? Where neither the son nor the father, so neither the heir nor the thief himself took a shavua. However, again the Gemara says, hu v'lo aviv lahu. What if he took a shvua, but ultimately again not his father? Aviv v'lohu, or his father took a shvua but not him. Now we'll say, by the way, these cases of halacha l'maisa, of a son going in and taking a shvua, we're gonna clarify these cases a little bit more. This would be, let's say, in a situation where the son swears an object of his father, right, that his father stole. That would be a case ultimately again of where the son was going and taking a shvuah. Huva lo aviv lo hu. Sigmar says huva aviv minayin. So ultimately again, where do we know about the case that halacha l'maisa where both he and his father, right? He and his father took a shvuah, and there wouldn't be an obligation of chomesh. Talmud Omar, asher gazal, asher ashak, v'hulo gazal, v'hulo ashak. So I will say the idea over here is the Torah indicates to us that the only time that there is a chomesh liability is for the person who actually stole. But if halacha l'maisa, the son, whether he's taking a shvuah or not taking a shvuah, so l'maisa again, because the son himself never engaged in the act of theft, therefore halacha l'maisa there would be no chomesh liability. All right, Rav Nachman says, so which one is it? So you just told me before about the son being obligated to pay back the chomesh, and now you tell me that the son is never obligated to pay back the chomesh. Rabbi say, you hear the contradiction? So in other words, you told me before that halacha l'maisa, if the father dies, the son is obligated to pay back keren, son is obligated to pay back chomesh. The only thing the son is exempted from is asham. Now you just told me that a son is effectively never obligated in chomesh. So what's going on? Very simple resolution. Rav Nachman lo kashya, kan shahoda, kan shalahoda. So I will say this is interesting. A very simple distinction. One is talking about a case. Remember, I will say, when is chomesh incurred? When is chomesh incurred? Chomesh is incurred when you swear falsely and then admit that you swore falsely. So therefore, I will say everything depends on the father. If the father admitted his liability before he died, then that generated a chomesh liability. When it generated a chomesh liability, and now if he dies, the son is obligated to pay back his father's chomesh. As opposed to father swore falsely, died, never admitted, then it turns out that it turns out that the father had stolen. In that case, the son is obligated to go ahead and pay back keren, but not obligated to pay back chomesh. In other words, both say, essentially what the Gemara is saying is like this. In order for the son to be liable to pay back chomesh, the chomesh liability must have been generated by the father before his death, which means he had to have admitted that he lied under oath, or he not he lied under oath, he swore falsely. That would generate chomesh liability. Son could inherit that liability. But if father never admitted that he lied, then under those circumstances it would not generate chomesh liability. All right, take a look at Rashi for just a moment. Kan shahoda aviv b'chayiv achar shenishba. So because the case where the son would be obligated to pay back the chomesh would be where the father went ahead and admitted during his lifetime that he went ahead and he lied. So again, if the father admitted that he owed chomesh, then ultimately again the child would be obligated to repay that chomesh. Okay, good. So Gemara says, Ila hoda. Now, whoa. If we're talking about a case where they both say the father stole, right, swore that he did not steal, and then we both say what? Never admitted that he lied, and then he died. So we'll say under those circumstances, halacha l'maisa, there shouldn't even be a liability for keren. Right? Let's say, remember again, liability for a false oath, right? You incur three things: keren, chomesh, asham. So asham, remember again, you're never going to be chayv asham. Why not? Did I miss something? Oh, okay. Sorry, I missed one of the sponsorships. Ramel Ram for joining us from Toronto. Le'ili Nishmas, his grandmother Esther Bas Yaakov, for Refuah Shlema for his father Mordechai ben Esther. We hope that in the merit of our Talmud Torah, the Neshama will have an aliyah, and his father Miras Hashem should be zocheh to refuah and arichos yomim v'shanim ameh ve'esim shanim tovos. Shkach Ramel. I saw Mel on. Mel's here with us. Good. Here with us on Zoom. Okay, excellent. All right, so I'll say sorry about that. So the Gemara says as follows. So if we're talking about a case where the father never admitted liability for swearing falsely, then what, Mashi, thank you. Mashi's full service, by the way. Heat sponsorships video, incredible. So now remember, if the father never admitted liability, so then again, if he never admitted that he swore falsely, then there should be no liability for keren either. Right? In other words, how is there keren liability if the father never admitted that he swore falsely? And if he did admit that he swore falsely, then not only should there be keren, but what? There should also be chomesh. So what's going on over here? To which the Gemara says, so maybe you'll say, you're right. This is talking about a case, if the father didn't admit, not only is he not liable to chomesh, he's also not liable to keren. Here's the problem. But that can't be. From the fact that we're engaging in a discussion about whether or not the son is obligated to pay chomesh, what does that tell you? That halacha l'maisa, he's most definitely paying Karen. Va'otanya, furthermore we learned, Va'adayin ani omer, furthermore again we also learned, Emasai hu mishalem Karen al gezel aviv, when ultimately again does the son have to repay back the principal of that which his father stole, Bisman shenishbahu va'aviv, in a case where ultimately both father and son swore, aviv v'lo hu v'lo aviv. What about the father and not him and not the father? Lo hu v'lo aviv, not him nor his father. Ultimately, again, minayin means how do we know that the son would still have to pay back Karen? Talmud gzela v'oshak aveda upikadon yesh Talmud. So we'll say therefore the pasuk talks about all these different forms of liability. We'll say again, remember, these are all different types of items for which if a person stole, right, and swore falsely, he would be liable ultimately to Karen and Chomesh. So the Gemara says, we say, right, all these items, Yesh Talmud. Now, I will say that phrase, we don't immediately know what it means. We're going to circle back to that in just a moment. Rav Huna was sitting and giving over this ruling. Rabbi Berei, so Rabbi's son said, that phrase, Yesh Talmud. Yesh Talmud Ka'amar Mar? Does Yesh Talmud means that this is a proper teaching? Oh, Yishtalmu. Or maybe somebody said Yishtalmu, they just said it really quickly, and it sounded like Yesh Talmud. So the Gemara says, Amarle, Yesh Talmud Kamina. No, I meant to say Yesh Talmud, that this is a good derivation. Umeribuya Dikrai Amri. We ultimately learned out liability from the ribuy in the pasuk. Elamai lahoda. So ultimately, I will say, what's the case of lahoda? Lahoda aviv vahoda bino. Ultimately, we're talking about a case where the father never admitted, ultimately again, that he had stolen, that he had swore falsely, but the son admitted that his father had stolen the object. If a son admits that his father stole the object, then what's the halacha? Then the halacha ultimately is that there's liability for Karen and not liability for Chomesh. So the Gemara says, I v'nechayiv b'no Chomesh ashvua didei. But I will say, if we're talking about a case over here, that halacha l'maisa, let's start talking about a case where the son swore that he had no stolen property with him. Right? He had swore that he had no stolen property with him. So ultimately, why wouldn't the son be liable to Chomesh for his own shvua? To which the Gemara says, Amri b'she'in gezela kayemas. We're talking about a case where the stolen property is no longer extant. It's no longer in existence. But if we're talking about a case over here where halacha l'maisa again, the gzela is not kayum, afilu Karen nami lo mishalim, then ultimately again he shouldn't pay back Karen either. To which the Gemara says lo tzricha. So we'll say again, if there's no good. Look at Rashi just a moment. B'she'in gzela kayames delav alei ramya lishalume. Now, both say, remember again, we're going to see that we've spoken about this already in passing before. But if father stole property, so obviously if that property is still in existence, then the son is obligated to give it back, right? And remember when we saw that, that's because halacha l'maisa, that's really in order to almost like clear the reputation of the father. If the stolen property, however, is no longer in existence, again, not because, let's say, the son used it up, just because it's no longer in existence, then son is not obligated to make restitution on behalf of his father. So halacha l'maisa, the Gemara says, we're talking about over here where the gzela is not kayim. Im b'she'in gzela kayemes, afilu Karen nami lo l'shalim. But 1 second, if halacha l'maisa, the stolen object is no longer in existence, then the son shouldn't be liable to Karen. Forget about Chomesh, is not liable to principal. To which the Gemara says, lo tzricha di'ika achrayis. So it says, it's interesting. What's the case over here? The case over here ultimately again is where the father had other real property. Take a look at Rashi. Lo tzricha di'ika achrayis nechasim. Rashi says, Varmin on the Kamma timheniach avihen achrayis nechasim karkaos chayaven lahachsim mipnei kavod avihen. So Rabbi say again another halacha. We're going to see this later on, that if a father steals, even if the stolen object is no longer in existence, nevertheless what? Halacha l'maisa, if there's other real property, the children are obligated to pay back the stolen object, or to pay back the value of the stolen object. Why? In order, out of kavod avihan. What does kavod avihan mean? Again, it restores the dignity and the reputation of their father. So the Gemara says, I will say, but even, okay, so now let's say we're talking about a case where the stolen object is no longer in existence. The father has other real property, and therefore we say that the children should repay the stolen debt of their father from other real property. At most, it's like a milva al peh, right? At most, at the end of the day, it's like a verbal transaction, like a verbal loan. So the Gemara says, milva al peh and a gova loan min hayarshin, and ultimately, again, a verbal loan is not collectible from inheritors, and not from purchasers. So I'll say, so therefore again, what would be the case if the children would be liable? Amri, top of Kufhei, Bisha Amad Bedin. Rabbi says, we're talking about a case where before the father died, he was already locked in a legal battle, right? In a legal issue regarding this theft. Ibisha Amad Bedin afilu chomesh na'im mishalim. But again, Rabbi say, we're assuming Amad Bedin means that what? Father stole, swore that he didn't steal, right? Then admitted ultimately again that he did steal. So that's Amad B'din. If that's the case, then we're kind of like going around in circles over here. If that's the case, then it shouldn't just be liability ultimately for Karen, but there should also be liability for Chomesh. Or if we read Rav Yeshua, the Fishein Mishamin Chomesh al Kfiras Shibud Karkos. So Rabbi said this is interesting that halacha l'maisa, because you don't go ahead and pay Chomesh when negating a claim that is backed up by real property. All right, and therefore there wouldn't be chomesh in that case. Rava Amar Rava says, what's the case over here? It's actually interesting. Kigon Shahai said the sakya shall aviv mufkedes biyad acherim. But we're talking about a situation where essentially, again, the father had property, but it was deposited with someone else, so the Yarshim themselves never knew about it. If that's the case, Karen Meshayim Daha Isei, you have to pay Karen because the stolen property is in existence. Chomesh lo Meshalim, but the son doesn't have to pay Chomesh. Why not? Techi ishtaba bekushta ishtaba dahu lo hava yada. But the son won't pay Chomesh. Why? Because at the time that he stole, at the time that he was swearing, he had no knowledge of his father's property. So I will say, Bottom line, what's the takeaway from this? So for our purposes, two major takeaways. Number one, Chomesh is mamon. Chomesh is mamon. Now I will say what I want to point out is something very interesting. Chomesh, really, if you think about it, Chomesh really sounds like it should fall into the Knas family, right? Because remember again, any fixed amount that you have to pay, that's not at all rooted in the value of the event that occurred, usually is a Knas. What the Gemara is saying is, it is a knas, but once incurred, takes on the status of mammon. That's why, let's just close the circle over here. That's why the Mishnah says, right, Reuven steals from Shimon, swears that he did not steal, admitted that he did steal. Now we'll say three-pronged liability, namely what is he liable in? Keren, Chomesh, Asham. Okay, Reuven dies before having a chance to pay any of that back. What's the halacha? Right? We know off the bat what don't Yarshim have to do? Asham, right? Why? You can't inherit carbonic liability. Right? Again, if let's say Reuven, I'll just give the qualification to that, right? Obviously, if Reuven designated an animal as a shlamim and then he died, so the kids bring it as a shlamim. But what it means is if Reuven himself had carbonic liability for that, carbonic liability is not transferable, non-inheritable. What do the kids inherit? The kids inherit the obligation for Karen and chomesh. So in that respect, once it's incurred by the father, then that same liability ultimately is carried on by the children. They have to pay back that Karen and that chomesh. Good, that's the takeaway. From our Mishnah's perspective, what we learn is once incurred, it's called mammon. How do we know that from the Mishnah? Because remember again, the Mishnah is talking about the obligation that if the thief wants to make good after swearing falsely, what does he have to do? Track down the victim. The Mishnah goes out of its way to say he only has to track down to pay the Karen, but if he, for argument's sake, paid the Karen but didn't pay the chomesh, he doesn't have to track down the victim to pay the chomesh. The fact that the Mishnah has to say that tells us that what? That chomesh itself is also considered mammon. Good, that's the takeaway. Let's go weiter. Says the Gemara, chutz mipachos mishaver pruta bekaren. So we'll say, so remember again. This is the follow-up case that if halacha l'maisa Reuven stole from Shimon, right, admitted that he swore falsely, liable for three things: Karen, Chomesh, and Asham, and then he paid off everything, right? Reuven paid off everything except for less than a pruta of Karen. So we'll say, what's the halacha? For less than a pruta of keren, he doesn't have to go ahead and track down the victim, right? Because less than a pruta of anything is not going to be halachically significant. Here we go. Amar Papa, lo shana ela shein gzela kayemes. So we'll say, when we say that the thief doesn't have to track down the victim for less than a pruta of keren, that's only if what? That's only if the stolen object is not extant. Right, if it's not extant, aval gzela kayemes. But Abba said, let's say halacha lamaisa again, the stolen object ultimately is kayam, right, is in existence. Then sarich leilech acharov. Then you have to go ahead. You have to go ahead and track him down. Chashinan shemati yaker. This is interesting. Why? Because we're concerned maybe it will appreciate and become more than a pruta. So Rabbi say, listen to how fascinating this is, right? So let's say for argument's sake, Reuven stole wheat from Shimon. Right, stole wheat from Shimon. So now what happens? He went ahead, same case, right? He swore that he didn't. He admitted that he swore falsely. He's chayiv keren chomesh asham. He pays back virtually all of the wheat to Reuven, to Shimon. But then Shimon, ends up going out of town. Right, or moving to the other side of the world. So now he's got, a couple of stalks of wheat left that are less than a pruta. So according to the Mishnah, okay, obviously Reuven still has to pay it back, but Reuven doesn't have to track down Shimon to the ends of the earth in order to do hashava. So Rabbi says, this is wild. So Rabbi comes along and says, when is that obligation that you don't have to give back less than a shava pruta you don't have to track down the victim for less than a shava pruta? That's only if the stolen object is not in existence. But if the stolen object is in existence, you have to track down the victim, even if the value of it is less than a pruta. Why? What are we concerned about? Appreciation. And maybe it will become more than a shava pruta, so therefore make sure you track him down and return it. So we'll say pretty wild, right? Ikadamri, yeah, we'll say this is great. There's an alternate version of this, which is exactly the opposite. Watch this. Ikadamri, Amra Papa, lo shana gzela kayemes, lo shana shein gzela kayemes. Truth is, we don't care. If it's less than a pruta, I will say, we don't care if the stolen object is in existence or not in existence. Eino tzarich leilech acharov. You do not have to track down the thief. Again, I will say, I want to be clear. You still have to give it back. But you don't have to track down the thief. Why? L'shemati yaker lo chayshinon. Watch this, I will say. In the second version of Rav Papa essentially says, we do not contemplate the possibility of appreciation. In other words, say, we look at what the object is. So right now, if Reuven stole from Shimon, and halacha l'maisa again, swore falsely, incurred liability, gave back most of the object or most of the stolen property to Reuven. But let's say now he has still some remaining stolen property. Reuven moves to the other side of the world. Shimon moves to the other side of the world. What Reuven still has left with him is worth less than a pruta. Worth less than a pruta. So again, is Reuven obligated to give it back to Shimon even if it's worth less than a pruta? Yes. You're obligated to give back anything. But remember, the mitzvah of hashava, of tracking down the victim, only applies if you have a pruta or more. So if right now Reuven has less than a pruta, he's not obligated to track down Shimon wherever Shimon may be. That he's not obligated to do. So Rabbi say, and what? And we don't say to ourselves, well, now it's worth less than a pruta, but maybe it'll appreciate. We don't do that. What we say, like l'shemati yaker, that something's going to become more expensive. We're not choshesh for that. All right. So I'll say, now watch this. We're going to get some really interesting cases over here. Amar Rava. So Rava says as follows: Gazal shalosh agudos b'shalosh prutos. So I'll say, watch this. Reuven stole from Shimon 3 bundles worth 3 prutos. Okay, now what happens? V'huzlu. Now we'll say, now what happens? The product depreciates, right? The bundles depreciate. V'amdu al shtayim. And I will say, now 3 bundles are only worth 2 prutos. So what's the halacha? So the Gemara says, v'amdu al shtayim. Im hechzir lo shtayim, chayiv lahachzir lo achares. So I will say, if halacha l'maisa, even if Reuven now returned 2, he's still obligated to return the 3rd. Now, what's unique about this case? Once he returned 2, what's the value of that 3rd? What's the value of that 3rd? less than a pruta. Yet again, the Gemara says he's still obligated to return it. In other words, it's stolen property, even though it's less than a pruta, you still have to return it. V'tana tuna, that's the part. It says gazal chametz va'avar lava pesach. I've seen this case so many times, but it's still exciting every time. So what happens? Reuven stole chametz from Shimon before Pesach, and then what happens? Va'avar lava pesach. Then Pesach comes. Now remember, again, both say this is now chametz sha'avar alava pesach, which is chametz owned by a Jew over the course of Pesach. What's the value of that chametz? Zero, right? So now what happens? So Reuven stole chametz from Shimon before Pesach. Now Pesach goes by, and the Gemara says, so Omer hari shachal lefanecha. So you've seen this already, that Reuven can bring the chametz back to Shimon, and what? Say here, I'm a Baal Tshuva, feels so good to be a Baal Tshuva, here's your chametz, I'm giving it back to you. So we'll say, remember again, that's the whole discussion of hezek she'eino nikar, unrecognizable damage. But in any event, Reuven could go ahead and give back the chametz to Shimon, and we're done. Taima di'ise be'enei. Now, ultimately, again, that's because the chametz is extant. Lessa be'enei. But ultimately, again, if the chametz is not in existence, Af agav dahashta lav mamona, kaven demei kara mamonahu by shlumi. So we'll say, now watch this. This is very exciting. Let's say, right, Reuven goes ahead and steals chametz from Shimon, okay, before Pesach. Pesach goes by. So if the chametz is still in existence, how does Reuven repay the debt? How does he repay the stolen item? If the chametz is still in existence, give back the chametz. Let's say the chametz is not in existence. What's Reuven's obligation? To pay back what? The value of the chametz as it was at the time that it was stolen. Even though now presently, what's the value of the chametz? Zero. So we'll say, what do you see from here? You see from here that halacha l'maisa, even though something depreciates, we don't care. Because this goes back to the theme that we locked in long ago, which is value of theft, right? Value or financial responsibility for theft is locked in when? B'shas gzela, at the time of theft. See, even though, so again, what's unique about chametz is if Reuven stole the chametz, Pesach passed over, huh? Right, Pesach passed, and now again the chametz is still in existence. Reuven has the ability to go ahead and give back that chametz, even though the value is zero. But ultimately, again, if the chametz wasn't in existence, Reuven would be obligated to make financial restitution. So we'll say, so too. The Gemara says, Hachanami. So in the case where you stole 3 bundles, right? And the 3 bundles were worth 3 prutos. You gave back 2. Now you gave back 2, and now the value of the bundles depreciated. So now the bundle's worth less than a pruta. What's the halacha? Doesn't matter, you're still obligated to go ahead and give it back. Okay, so boy Rava. So we'll say Rava says as follows, Gazel shtei agudos bepruta. So we'll say Rava gives out another case. Let's say Reuven stole 2 bundles, and the 2 bundles together we'll say worth a pruta. 2 bundles are worth a pruta. Vehechselo achas mehen. So it's an interesting case. So now what happens? Now Reuven gives back to Shimon one of the bundles. So we'll say, so now remember, this is not a depreciation case, right? This is where the value is the same. But what's the difference over here? Reuven gave back 1 bundle, he's left with another bundle. So there's still another bundle in his possession that's worth less than a pruta. So mahu, what is the halacha? Mi'aminan hashta leka gzela. So we'll say, so ultimately again, do we say that essentially Reuven doesn't really have stolen property with him anymore, right? Why not? Because all he has left with him is what? Is 1 bundle that is worth less than a pruta. So maybe halacha doesn't recognize that he has stolen property with him anymore. Odilma ha lo hadir gzela tahavigabe. We'll say on the other hand, that halacha l'maisa, maybe he hasn't really fulfilled the mitzvah of returning the stolen object. Why? Because he has not yet returned property worth a full pruta. Remember again, all he did is return 1 bundle, which is worth ultimately again half a pruta. To which the Gemara says, Hadar Pashta, he answered, Gzela in kan, Hashava in kan. Ultimately, there's no theft and there's no return. The Gemara says, what does that mean? Gzela in kan, Hashava yishkan. So I'll say, if there's no theft, then how could there be a return? This means to say, Afa pishek zela in kan, mitzvahs hashava in kan. So we'll say ultimately again, even though technically speaking, he's not really right. He's not really considered to be in possession of stolen property anymore because it's worth less than a pruta. But lamaisa, he has not yet performed the mitzvah of hashava. Or as we're both saying, in order to fulfill the mitzvah of returning a stolen object, you must return property at a minimum value of a pruta. So therefore, again, if Reuven stole 2 bundles, those bundles together are worth a pruta. He returned 1 bundle. So again, I will say, so it's this interesting case. So he has returned property, but he has not fulfilled the mitzvah of returning stolen property. Because the mitzvah of returning stolen property is only fulfilled when you return at least a pruta's worth of property. And in this case, all you've done is returned half a pruta's worth of property. So therefore, in order to fulfill the mitzvah of hashava, he would have to return the other bundle as well. So we'll say some other cases that are like this. Hari Amru, this interesting case. Nazir shegilach v'shir shtei sa'aros lo asav lo klum. So we'll say, so remember again, a Nazir at the end of his Nazirite vow has an obligation to shave his head. And now it's true, this is not just only at the end of his Nazirite vow if he becomes tamei, okay? But the point over here is when a Nazir has an obligation of giluach, of shaving his head, he has to shave everything. If Nazir leaves over 2 hairs, lo asav lo klum, then it's not a shaving. Right? So I will say what you see from here is 2 hairs. 2 hairs, if the presence of 2 hairs means that his head is not shaved. Okay? His head is not shaved. So I will say, take a look at Rashi. Rashi says over here, Amar le Rav Acha le Ravina Nazir shegilach. No, I'm sorry, not yet. So by Rava. So Rava said as follows. What about the following case? Gilach achas v'nishra achas mahu. So listen, now watch this. Let's say the Nazir shaved his head. He left over 2 hairs. Okay, so now he's got to remedy this situation. So let's say he's got 2 hairs left. Let's say he cuts one of them and one of them falls out. So what's the halacha? What's the halacha in this case? Mahu. So we'll say, what's the halacha? And I will say, now what's unique about this case? Now normally if a Nazir would shave his head and leave over 2 hairs, what would we say? Okay, you have a mitzvah of giluach. But we'll say, the mitzvah of giluach, the minimum shear for the mitzvah of giluach ultimately is 2 hairs. So let's say there were 2 hairs left over, 1 fell out, right? Or gilach achas, he shaved 1, but 1 fell out. So is that the mitzvah of giluach or not? Mahu. So the Gemara says, so what's the halacha? Amar le Rav Acha me difti Ravina Nazir shegilach achas kami baile le Rava. So the Gemara says, so what is Rava asking? Is Rava asking? Let's say a Nazir were to shave his head, but he would literally cut 1 hair at a time. So we'll say, wouldn't everyone agree that at the end of the day, as long as he has no hair, by the time this process is complete, that Allah again his head is shaved? So what's the shayla? Amrle lo tzricha kigon shenashar achas mehen v'gilach achas mehen. So we'll say this is interesting. What's the case? The case is where he had 2 hairs left, right? He had 2 hairs left. 1 of them fell out, and he shaved the last one. What's the halacha in this case? Mi amrinan hashta mihas halak ashir. So we'll say, on one hand, do we say that at the time that he gets to the last hair, there's not a shear of giluach? In other words, we'll say halachically, in order for something to be considered proper head shaving of a Nazir, there's a 2 hair requirement. Here he doesn't meet the 2 hair requirement. Odilma halav giluachu t'mei kara hashir shtei saros v'hashta kegilach lo havi bei saros. So also do we say no, that at the end of the day, the sheer giluach is fundamentally missing over here. Why? He left over 2 hairs. If you leave over 2 hairs, what's the obligation? I'll say, if you leave over 2 hairs, that means you did not shave your head. Now, so we'll say, if you didn't shave your head, what's the Nazir's obligation? What's his obligation? Shave his head. What's the minimum shear of shaving your head? 2 hairs, which means if 1 falls out and he's left with 1, he didn't fulfill the mitzvah of giluach. So we'll say, could very well be that what does he have to do? This is incredible. What does he have to do? He has to let his hair totally grow back again, and then he could shave it off. We'll say, you hear what's happening over here? If a Nazir, just watch the dynamics of the case. It's so fascinating. A Nazir shaves his head. He left over 2 hairs. If you left over 2 hairs, then halachically, what's your status? Unshaved. In other words, leaving over a full head of hair, I don't know why I'm going like this, right? But leaving over a full head of hair, right, or leaving over 2 hairs are the same thing. It's the same thing, which means you haven't shaved your head. So now he left over 2 hairs. One of them fell out, which now means there's only 1 hair left to shave. Well, shaving 1 hair is not the mitzvah of giluach. The minimum mitzvah of giluach is 2 hairs. So maybe we should say, listen, I'm sorry, at this point, you can't fulfill the mitzvah of giluach. So what do you have to do? Let it all grow back, and then you'll shave it and fulfill the mitzvah of giluach. Incredible. So the Gemara says, Hadir Pashte, he answered, Sar inkan, giluach inkan. He answered, there's no hair in this case, and there's no shaving in this case. Gemara says, I don't understand. Once again, that formulation doesn't make sense. Isar inkan, giluach yishkan. So I understand that if there's no hair, could there be any shaving? Hakar means to say, Afa pisha ser inkan, even though again, let's say you have a case over here where the Nazir has no hair, nevertheless, mitzvahs giluach inkan. Nevertheless, he cannot fulfill the mitzvah of giluach. So I will say, sounds according to the Gemara, what you would have to do in a case like this is pretty wild. What you have to do in a case like this is what? Let your hair grow back, and do a proper giluach. So I will say, because the technical issue over here is the mitzvah of giluach, of actively shaving your head. So I will say, let me say it differently. What you see from here from a Nazir is, it's not the mitzvah of shaving is not that you should have no hair. The mitzvah of shaving of a Nazir is that the Nazir removes his hair. So therefore, again, in a case where he doesn't have the minimum shear of hair to remove, he can't fulfill the mitzvah of giluach. So therefore, again, he shaved his head. He left over 2 hairs. He hasn't fulfilled the mitzvah of giluach. One of those hairs falls out. So now he only has the ability to actively remove 1 hair. That's not the mitzvah of giluach. So what would he have to do? He'd have to wait for his hair to grow back in and go ahead and shave his head properly. Pretty incredible. So Rava says, Hari Amru. What about the following case? Chaviz shenikva visasmu ashmarim. So we'll say, okay, this is actually an interesting case over here. So imagine the following scenario. You have a house. House has 2 floors. There is a hole in the roof, right? Right. So there's a hole in the roof, right in the ceiling, between floor 1 and floor 2. Now, both saying, I remember what's the halacha? If somebody dies on floor 1, so what's the halacha? Both say there's tumas ohel, which means tumas may spread throughout the entire home. Normally, if there's a ceiling, right, between floor 1 and floor 2, that can mean that the tumah could be contained to floor 1. If there's a hole in the ceiling between floor 1 and floor 2, then tumah ascends. Now, this is an interesting case. If you have a barrel, let's say you have a barrel, right, an earthenware barrel, that it plugs the hole in the ceiling between floor 1 and floor 2, then what? That's chotzetz bifnei tumah. That's a barrier that keeps the tumah ultimately again on floor 1, and it doesn't ascend to floor 2. Take a look at Rashi. And now in our case over here, you plug the barrel, you plug the barrel in the hole, but then what happened? Now there's a hole in the barrel. So obviously we'll say if there's a hole in the barrel, then what's the halacha? The tumah once again ascends from floor 1 to floor 2. There's only a whole barrel, plugs only a complete barrel prevents the tumah from ascending. But if halacha l'maisa, the barrel itself has a hole, then the tumah is ola b'kas. So Rashi says over here, chavish nikva v'sasmua. Let's just read it in the Gemara. Chavish nikva v'sasmua. Chavish nikva v'sasmua shmarim. Hitzilos. We'll say. So now watch this. So if the barrel has a hole, well, what happened? Well, so let's say this is a wine barrel. So the dregs, right? The dregs in the barrel itself plugged the hole. Then what? It works, right? Hitzilua also means it saves the house, or it saves the saves the house from or it saves the second floor from having the tumah ascend. By Rava, agav chatziyamahu. So Rava asks following kasha: what happens if the barrel has a hole and you plug the hole partially? You plug the hole partially. So we'll say, so not totally, but partially. What's the halacha? Amrle Rav Yemar Rav Ashi Lav Mishnah Seinuhi. Is this not a Mishnah? This now we learned Chavish Nikva. If you have a barrel that has a hole, Visasmua Shmarim, and then the dregs filled up the hole, and now again, so the barrel no longer has a hole. Hitzilua. Ultimately, again, they saved the second floor from Tumah. Pocket kab bizimura, but let's say you plugged up the hole with some vines. Ad shimarach. So we'll say vines by themselves won't plug up the hole until like you plaster the area around the vines, right? Sealing it up. Hayu bashtayim. Even if there are 2 vines in there. Ad shimarach min atstadim ubein zmura lechaverta. Even then, I will say again, you still have to plug up the open areas between the vines and around the vines. So I will say time of demarach. The only reason why the vines are helpful is if you plaster the remaining open area. Halo marach lo, but if you didn't plaster, it doesn't work. Now, what do you see from here? You see from here that if you have a hole, even if you partially plug up the hole, that doesn't help regarding tumah. It's got to be fully filled in. So the Gemara says, V'amai. The Gemara says, Amai. V'tehavi ki agav chatzia. Why shouldn't it be? I will say, in other words, we're not getting into this now, but obviously only a hole of a certain size allows the transference of tumah. So really, I don't need to fully plug the hole. What do I just need to do? What do I just need to do? Minimize the hole. Minimize the hole, right? So again, if I have vines or I have other stuff in there, so let's say for argument's sake, the hole in the barrel was exactly the size that allows for the ascension of tumah. So why should I have to plug up the whole hole? All I need to do is what? Plug up part of it. So therefore, in a case where you have vines in there, that should be enough. Why should you have to plaster any other open areas? So what's going on over here? Switch the Gemara says, V'te'avi. Time the marach halo marach amai v'tehavi ki agav chatzia amri hachi hashta hasam kilo marach lokai agav chatzia b'midi de kai kai. Both says a big difference. In the case where, let's say again, you plaster up half of the hole, that filler remains in place. The problem with the vines, I will say, is when you stick vines into the hole of the barrel, if they're not plastered, then what? They don't remain in place. This just says it's a practical issue. Rava says, listen to this, back to chametz. Hari amru, gazel chametz v'arva lava pesach. Omer la hari shachal lefanechas. Well, so we've seen this case many times already, right? Reuven steals chametz from Shimon before Pesach, and then what happens? Pesach goes by. Reuven wants to be about tshuva. The chametz is still in existence. What does Reuven do? He gives back the chametz to Shimon. He says, Shimon, here is your chametz. Rabbi will say, that works. That works. So by Rava, Rava asks the kasha. Will say, Amud Beis by Rava, nishpa alav mahu. So we'll say, now watch this. What happens if after Pesach, so right, Reuven steals from Shimon before Pesach. After Pesach now, Reuven is confronted with the fact that he stole from Shimon, and Reuven swears that he did not. He swears that he didn't steal, right? Nishpa alav, Rashi says over here, Nishpa alav la'achar shene'asar nishpa she'inetz lovelo gazl mimenu. So we'll say, Mahu, what is the status? Right? What is the status? So we'll say, so now remember, what's interesting about this case? Technically speaking, Reuven is denying something that is worthless. Right? Technically, it's because why? Because chametz, after remember, the chametz is in existence. Chametz after Pesach, right? Chametz after Pesach is aser, and therefore not worth anything. So we'll say, Mahu, watch this. Kevan di mignav by shlumele mamona. So, sorry. Kevan di mignav by shlumele mamona ka kafrale. Al dilma hashta mihas hamanach va'afra ba'almahu v'lo kafrale mamona. So Rabbi will say, this is a fascinating question. So how do we look at this case? Do we say, on one hand, right, if the chametz, let's say, were to disappear, the chametz were to be stolen from Reuven the thief, then Reuven would be obligated to make monetary restitution to Shimon, right? What would he have to pay back Shimon? What do you have to pay him? Right, the value of the chametz time that it was stolen. On the other hand, right now, if Reuven has the chametz in hand, and he could pay back Shimon with that chametz, and that chametz is technically valueless. So I will say, essentially, we're asking over here, do we view Reuven as having sworn falsely regarding an item that is a shava pruta or not a shava pruta? On one hand, it's a shava pruta because halacha l'maisa, if the object was stolen, he would be obligated to pay back the value of the item at the time it was stolen. On the other hand, if it's extant, he could just give it back and it's valueless. So do we view Reuven as having denied a valuable item or a valueless item? Such a great kasha. To which the Gemara says, that which was a question according to Rava, ultimately, again, was obvious according to Rabbah. Why? We'll say, what's Rabbah's case? Here we go. Dama Rabbah, Shori Ganafta. Listen to this case. Right? Shimon goes over to Reuven. Reuven, you stole my ox. Omer lo ganafti. Reuven says, Chas v'shalom. I didn't steal your ox. So Shimon says, okay, Mativa etzlecha. Shimon says, that's funny because that's my ox. and it's in your yard. So right, so tell me exactly what Ruvain, paint the picture for me, right? Paint the picture for me. Why is my ox in your property if you didn't steal it? So Ruvain says, very simple, very simple. Shomer chinam ani alav. I'm a shomer chinam. Right? In other words, you deposited it with me to go ahead and watch it. So now here's what's interesting. What's interesting about these cases over here is Ruvain is admitting that the ox belongs to Shimon. Right? He's just claiming that ultimately, again, he is a shomer chinam. He's supposed to say, what's the halacha? Chayiv. Ultimately, I will say now he's going to be chayiv. Rashi says over chayiv karban shvua afapi shahoda kodem shvua b'guf hamamon. So ultimately, we're going to see that Reuven has liability. Now, why does Reuven have liability in this case? Shari pater atzmam b'gneva v'aveda. Because I will say, by claiming that he was a shomer chinam, he was covering himself from certain liability, right? Because a shomer chinam is pater on geneva va'aveda. So ultimately, again, there's going to be liability for that. Shomer, or let's say, same case. So in this case, Reuven claims shomer sachar ani. I'm a shomer sachar, right? I'm a paid custodian. In that case, there's also going to be liability. Chayiv. It's going to be chayiv a carbon asham. Why? Shari pater atzmo mishvura umesa. Because also remember again, by denying that he stole it and claiming that he's a shomer, he also shielded himself from liability. What type of liability? Right? Ultimately against shivura and mesa. If the animal dies or it breaks, right? He gets injured. Shomer sachar is pater. Shoel ani alav. But say all these cases are the same, right? Shimon's coming over to Reuven, you stole my cow. Reuven's saying, no, I didn't. Shimon says, no, so why is it in your property? To which Reuven is responding, I'm a shoel, I'm a borrower. So we'll say same thing, chayiv. Once again, Reuven is going to be liable. Why? Because we'll say once again, by claiming that I'm a shomer chinam, I'm a shomer sachar, I'm a shoel, what Reuven is effectively doing is, while he's not denying that the animal belongs to Shimon, by claiming these things, he's trying to shield himself from liability. Alma. So we'll say, what do you see from here? So we'll say, what you see from here is, we'll say that even in cases where you swear falsely, even though, again, there's no financial liability. In other words, Rabbi said, because remember, again, let's say, for example, in these cases, Reuven is agreeing that the animal goes back to Shimon. Right? So in other words, he's agreeing, he's not depriving Shimon of anything, so effectively, he's not generating financial liability in the oath. Nevertheless, Kevan, the imignav mamona kakafar, since we're about to say in the event that the property, if it was stolen, Reuven would be on the hook for it. Therefore, again, it's considered as if he's denying financial liability. Hashtanami mamona kakafar. So I'll say ultimately, again, so to over here, so therefore he's considered as if he's denying financial liability. So we'll say, let's go full circle. Remember, what was our case? Our case was Reuven stole chametz from Shimon. Now Pesach went by, right? So now Shimon comes to Reuven, you stole my chametz. Reuven says, I swear I didn't steal your chametz. Now then Reuven admits that he stole the chametz. So I'll say, so what's the shaila? So is Reuven liable or not? Because at the end of the day, right, if the chametz were to be stolen from Reuven would have to make restitution in the value of the chametz at the time it was stolen. On the other hand, if the chametz is in existence, Reuven has the ability to just give it right back to Shimon. What's the value of that chametz? 0. So maybe Reuven's not really denying a viable financial claim. So that's our shayla. Do we say, since if the object was stolen, Reuven would be on the hook for the financial value, therefore what? Therefore this is a case of denying financial liability. So the Gemara proves, we'll say from here, that you see in these cases of the shomrim, right? Where Reuven has the animal, Shimon says, Reuven, you stole my animal, and Reuven swears, no, I didn't steal it, I was a shomer chinam, a shomer sachar, this, that. In these cases, right, Reuven just has the ability to give back the animal to Shimon. Right? There's no loss, so to speak, right? There's just a wash. I'm just giving you back. On the other hand, if the animal were to be stolen from Reuven would be on the hook for it. So what do you see from here? That essentially the way we assess liability is, even if the item is quote unquote valueless now, but if it were to be stolen and you would be liable, then denial of that claim is denial of a valid financial claim for which there is liability. To which the Gemara says, Good. Hachanami, first wide line. Hachanami, afagav da afra ba'almahu soter gases. And the side. So too in the chametz case, even though right now that chametz is valueless, kevan di mignav by shlumele mamona ma'al yahashtanami mamona kakafrle. So in the chametz case, even though right now the object itself, when it's in existence, is valueless, and you could return that, since if it were to be stolen, you would have to make financial restitution. Therefore, again, denial of the chametz is considered to be denial of a viable financial claim, and therefore there's liability. Yosef Rava the Kamma lahashmaita. So Rava said, we were saying over this ruling. Say Rav Amram the Rava. So Rav Amram raised the kasha to Rava. The kicheshba. So we'll say the pasuk over here is talking about halacha l'maisa, where let's say you find an object, right, and you deny that you find it. You deny that you find it, that you found it, and you swore that you don't have it. So Rabbi says, so then again, that's the halacha of keren chomesh asham. So v'kicheshba prat lemoda be'ikar. So Rabbi say, what does this come to exclude? This comes to exclude a case of where a person admits that he owes the object to the other party. For example, Ketzad, Shori Ganafta, right? Shimon comes over to Reuven, you stole my ox. V'hu omer lo ganafti, and what happens? And Reuven says, no, I never stole it. Shimon says, ma tivo etzlecha. So now what happens? So now Shimon says, okay, if you didn't steal it, then why is my animal with you? So Reuven responds, ata machartali, you sold it to me. Or ata nasatli matana, you gave it to me as a gift. Avicha machrali, your father sold it to me. Avicha nasli matana, or your father gave it to me as a gift. So the Gemara says, Achar parasi ratz me'elav. Or Reuven says to Shimon, you know what? I didn't steal your cow. You know what? Our cows kind of have a thing going on, right? So your cow ran after my cow, right? Ba'etzli, right? So I'm sorry, ratz me'elav. Ba'etzli, toa b'derech masasif. Or ultimately, again, it came to me. Or I found it wandering, in the field, and so I took it in. So Rabbi say, or shomer chinam ani alav. Or I'm a shomer chinam. Shomer sachar ani alav. Or I'm a shomer sachar. Shoel ani alav. I'm a shoel. V'nishba. In all of these cases, Reuven swore that this is what happened, and then Vahoda. Then he admitted that he lied. Right? He admitted that he stole it. So Rabbi say, watch this. You might have thought that Reuven should be chayiv in this case. It's incredible. No, there's no liability here. Why Rabbi say prat lamoda beikar. So Rabbi say, this is incredible. So now Rav Amram says, in these cases, no liability. Rabbi say, now, why is there no liability in this case? The only time there's liability, Rabbi say, is when you try to deprive someone of something. Rabbi say, in these cases, is Reuven trying to deprive Shimon of anything? Trying to deprive him of anything? No, technically no. Why? Because in all of these cases, Reuven is admitting that who does the animal belong to? Shimon. What is he lying about? He's lying about how the animal got into his possession, right? So what really happened over here is that Reuven stole it from Shimon. That's what happened. He's lying and he's saying that at the end of the day, I'm a shomer sachar, I'm a shomer chinam, I'm a shoel, you sold it to me, you gave it to me as a gift, whatever it is. Again, I will say, but in these cases, he's agreeing that at the end of the day, the property belongs to Shimon. So Rav Amram posits in that case there's no liability. So the Gemara says, Amarle Tidura. So Rava said back to Rav Amram, Tidura Rabbi is a shtickle insult. Well, actually, it's not a shtickle insult, it's just an insult. Tidura means you lost your mind. Ki tanya ha'i deka Amarle Halech, ki ka'amina dekaima ba'agam. This case, Rabbi is where Reuven says to Shimon here, take the object back. Take it back. So in that case, I will say he's admitting. He says just take it back. What I'm talking about is a case where the object is not yet in existence. The object is not with the current thief. The object, let's say, is in the swamp, so it's somewhere else. In that kind of case, ultimately, again, there would be the possibility of depriving. So I will say, so we'll stop over here for today. We'll pick up with this case. So I will say, some really fascinating scenarios over here. I will say, Shikayach, we'll stop here and pick up with this case and halacha l'maisa tomorrow. Incredible.
Bi-weekly question.
Yes.
Originally I thought you said that if the thing wasn't extant, that he didn't have to pay it back. That was case A. And in case B, they said even if it wasn't extant,
which situation?